Welcome and thank you for joining Sci-Fi's webinar, Trade Secrets and Non-Competes Year in Review and What to Expect in 2024. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I'd like to turn the program over to Mike Wexler. Mike, you may begin.
Thank you. Good morning and welcome to our webinar. You have with you this morning Kate Pirelli, a member of our law firm executive committee, co-chair of our trade secret non-compete group, Robert Milligan, co-chair of our non-compete group, and myself. We are doing our annual review, letting you a little know about what happened last year, as well as looking into and picking out our crystal ball and deciding what's going to happen next year, sort of. We'd probably pick stocks if we were really good at it, but we'll try and let you know what's going on legally. Here's our agenda for our 1 hour webinar. We're going to talk a little bit about the federal landscape because that's been very active this past year and will be active this coming year. We'll then get into some new legislation and judicial decisions around the country by region. We'll also talk about California's new non-compete law, which is of great interest, frankly, to many of our clients on a daily basis with the new laws that just went into effect. I'm sure Kate and Robert and myself can give you a number of anecdotal pieces of information that we've garnered from our clients over the past several months, and certainly very active now that the law has gone into effect. We'll give you a quick update on trade secrets and what's going on in that area, and we'll give you a quick update on a computer fraud area. And then after that, we'll give you the seminar or webinar, I should say, code that you can get your CLE credit. Moving on, let's start with the federal update. The FTC, as many of you may know, and if you don't, this will be new, the FTC has been quite active in trying to pass a national policy or law that would essentially eliminate non-compete agreements in all but very specific circumstances, including sales of a business or potentially in certain other situations specified by the statute. They started this process in early 2023, pursuant to the rules that the FTC must abide by. That was put out for public comment. There were approximately 27,000 comments that came in. This ban would also affect non-disclosure agreements that were de facto non-compete agreements. The ban would also affect non-solicits as well. So non-compete is, I suppose, a very broad term as to what that takes into account in the FTC's mind. There have been a number of public forums in which members from the FTC, folks from the FTC legal department have spoken. There have been a lot of trade associations that have had seminars and engagement with the FTC on this topic. And the topic's hot. I mean, that's frankly, one of the hottest topics for the past year and will be going forward. It's anticipated that in approximately April of 24, the FTC will vote on this. It is likely that organizations may file lawsuit against the FTC in order to enjoin or to prohibit the enactment of what the FTC passes. It's also possible, if we're just guessing a little bit, but it's an educated guess, that the FTC may back off its very, very stringent view of the current proposal and may reach a compromise position. The compromise position may be similar to some of the rules that have gone into effect in approximately 23 states around the country, where different states have put into effect limits, dollar limits and professional limits. as to individuals to which non-compete agreements may apply. So the FTC may go that route and limit its application, but we're just guessing. The question becomes, how do they either reach a compromise or have a long legal battle? And there's some pretty good precedent within the past 2 years where the EPA did a similar thing, and the Supreme Court had to chime in on that. And the Supreme Court took a view that the EPA had overreached and overstepped its authority, which is analogous to the current situation and may be a way of forecasting what the Supreme Court may do if this particular rule went that direction. The rule then would come out in the spring of 2024. And of course, if you go to our website at tradesecretslaw.com, always up to date with the hottest, greatest news when it comes to non-competes, trade secrets, computer fraud and abuse, and other related topics. Our award-winning blog, I should say. So feel free to check there routinely or get a feed from that, and you can get up-to-date current information. Oops. Here we go. The non-compete area has also been hot within Congress. Congress has had different bills brought before it seeking to limit or ban non-competes in one form or another. And by the way, the justification seemingly for some of these things is either employee mobility, employees moving back and forth between companies in their profession, or employee wages, that there's a perceived effect that somehow non-compete agreements suppress wages and workers can't get paid as much. Businesses would give you a very differing view, and businesses would say, well, we as a business invest millions, if not billions of dollars into the development of, it could be technology, it could be drugs, medicine, healthcare, it could be anything. And with that investment, they need protections to make sure someone doesn't sit in their shop and then move next door and do the same thing. And so there seems to be a divide between the real life business experience and the theoretical experience that is being used as a justification for some of these things. And as you can see on the screen, there's a few examples of congressional attempts to limit non-competes and workforce mobility. February 1st, 23 is a bipartisan effort to enact the Workforce Mobility Act of 2023. And that, of course, hasn't been passed. So if it did and went further, we would let you know. But that's just one example. February of 2023, another bipartisan effort that would ban non-competes for anyone that's not exempt under Fair Labor Standards Act. So they're even bringing in another factor, not just simply their non-competes, but throwing a factor of the application of Fair Labor Standards Act. Finally, another example, in March of 23, the Physician Access Reauthorization Act was introduced, and that was primarily geared towards immigration issues for physicians in certain communities, but would ban non-competes for those that would be covered by the act. And so those are a couple examples with regard to Congress. The NLRB has been extremely active on this topic, with numerous comments coming out from them. In particular, May 30th memo, in which the NLRB claims that non-competes interfere with workers' rights, worker mobility. They idealistically say that employees have a right to self-organize, join labor organizations, bargain collectively, and engage in concerted activities, and that their view is that non-competes interfere with that. And of course, businesses would most likely take a differing view. They also conclude that non-competes violate, at least in the NLRB's view, Section 8A1 of the Act, and makes it unfair labor practice. Of course, many businesses aren't thinking about the NLRB and being unfair to labor, as opposed to protecting investments in customers, investments in training, investments in what it takes to develop a product or service to the public. So very differing views there. The NLRB GC's rationale, as we talked about, generally claims that non-competes are overbroad and that it prevents people from switching job or cutting off employment opportunities. And again, business has a very differing view of that. They also claim, and it's at least in my opinion, it's difficult to see the correlation that somehow non-competes chill protected activity. And it discourages folks from resigning en masse and conservatively seeking to join a competitor, which of course, that's their opinion. Others have different opinions. And certainly business owners have a very differing view on that topic. The NLRB, you can go into more detail here. There's a lot here in this slide, and you can take a look at this. And I believe our slides may be available after the presentation to take a look at. I don't want to sit here and read all this to you, but as we were just discussing a moment ago, the NLRB has been active in going after folks. And in the fall of 23, there was a complaint filed with regard to non-compete. There was an offer letter and a policy employee handbooks, and they said violated the National Labor Relations Act. And in that situation, there were several competing issues with regard to whether the confidentiality provision was overbroad because it limited or prevented the disclosures of salaries, bonuses, and compensation packages, because it appears that the agreement in question and the policies in question didn't have the express language that that many practitioners would say include language that says none of this is meant to interfere with concerted activity or to prohibit proper disclosure or uses of confidential information with regard to protected activity. So there may be a unique situation in this particular case. But of course, there's also a non-compete provision that had a 2-year limitation in it, which the NLRB took a very dim view because it prohibited activity within 20 miles of the particular location that someone worked at. And then there was, of course, an exit agreement that had an acknowledgement that that they thought was pretty onerous with regard to damages and costs. So the NLRB took that on. There's a motion to dismiss that was filed and was denied in 2023 at the end of the year. The SEC, because every single organization with 3 or 4 letters as an acronym has to chime in here. So the SEC has also been active in this area and brought claim this year against JP Morgan, which included non-competes and covenants with regard to settlement agreements, and that the SEC has taken the view that some of this, the confidentiality and non-compete provisions in certain settlement agreements, particularly with, I guess you'd say, brokers and other financial service individuals, that's overstepping as well. And so the SEC has taken the position that some of the confidentiality language was overbroad and would prohibit the disclosure of essentially wrongdoing or government inquiries into information that that an individual might disclose, but for the agreement. Again, those are potentially, and not commenting on this particular case, but just potential drafting issues when you should consult with your professional, with an attorney, as to how to draft agreements, settlement agreements, and employment agreements. They include appropriate language that does not prohibit the disclosure of confidential information pursuant to protected activity, pursuant to investigations, pursuant to disclosing information that would show wrongdoing or potentially testimony about wrongdoing. So the SEC has also chimed in here. And then finally, the DOJ, because it's another agency with 3 letters. They, as you may recall, they've been very active with regard to non-solicit cases over the past several years. No poach cases. They've gone after businesses. You may recall the high-tech industry class action lawsuits and the DOJ action, where companies were agreeing not to hire each other's folks. In any event, the DOJ brought several actions in the area, seemingly not too successfully. And the most recent DOJ case that was brought in for a no poach situation went to a jury and there were no convictions. And so to our knowledge, and we've actually been looking at this, to our knowledge, there may not be any currently pending DOJ no poach cases, and this may signal a refocusing or maybe a different set of priorities at the DOJ, some other fish to fry, as it were, going into the future. At this juncture, I think we'll turn this over to, I think, Kate, who will talk about some regional legislation and judicial decisions of interest.
Great. Thanks, Mike. Yeah, I'm going to focus on the Eastern region, and Robert and Mike will cover the other regions of the country. In the Eastern region, there's not a lot of notable statutory changes. There are some interesting cases, though, that we'll go over. The one statutory change was in Connecticut. And Connecticut, as I'm sure many of you know, is a common law state with respect to non-compete law. It follows a 5-part test of reasonableness, which we won't go into here. But they have had, for some time, I think since 2016, if my memory is correct, a statute that governs the use of non-competes for physicians. And then recently, effective in all material respects on October 1st of 23, there's a new statute modifying that physician's non-compete statute to extend to physician's assistants as well as advanced practicing RNs. And the primary changes there is that the new law will apply to any non-competes entered or amended, extended, or renewed after the 10/1 date. They'll be unenforceable unless the physician or the other 2 categories of medical professionals, unless they've agreed to a proposed material change to their compensation terms. They've also always had a primary site of practice limit, 15-mile radius, and that's been defined by the area of practice of the physician. That now going forward, according to this amendment to the statute, the primary site of practice, still a 15-mile radius, must be mutually defined by the parties. It's also not going to apply to group practices with fewer than 35 physicians in which a majority of ownership is with the physicians. Certainly if you have non-competes governing these types of folks, physicians assistants, and advanced practice registered nurses, you should take a look to make sure that those comply with this new law. And go to the next slide, please. In New York, there was a lot of commentary and press on the proposed non-compete ban in New York, and this went on all of last year, pretty much, but perhaps even a little bit the year before. And the law would have applied to any worker, employee, or independent contractor. There was a penalty provision as laid out here in the slide of $10,000 per violation, in addition to lost compensation, damages, attorney's fees, and other costs. The bill was the subject of intense lobbying from Wall Street, hospitals, and other business groups that opposed the really broad nature of the bill. Many of the other states across the country have had other limitations, like wage limitations on low and mid-wage workers, as well as other types of reforms, but not too many states have gone this far. And it was approved by the legislature in June of 23. It kind of sat with the governor for a long time. There's all kinds of speculation and, office pools and trade secret group pools and non-compete group pools on what the governor was going to do with it. And she finally vetoed the bill. And there hasn't been a lot of direct comment by the governor, other than a few statements to the effect that she had hoped the legislature would either deliver a different bill with sort of not a complete ban, but a focus on, again, mid-level and low-wage workers, and focused on C-level executives and sale of business type situations. So I'm sure we'll see renewed activity on that front in the new year. The governor essentially invited that renewed activity, and I'm sure we'll see it pretty soon. We'll see what happens. We'll keep you updated and stay tuned on our blog on that. So there have been a number of interesting cases and precedents that have come out of Delaware. And it could take a long time to talk about these, and I'll try to go through them pretty quickly. But Delaware has always been a pretty friendly state for companies who have incorporated there and have Delaware choice of law provisions and sometimes foreign provisions in their agreements. And the Delaware courts have typically respected those if they are reasonable. But several cases of late are signaling an uphill battle for those using Delaware law for restrictive covenants, even in the context of the sale of a business, which is typically afforded a lot more deference in the context of enforcing non-competes. The first one here, and I'll go through quickly, and as you all know, the Delaware Chancery Court has vice chancellors. I think there's 5 or 6 of them now. And it's due to expand even more given the number of cases that court receives. A number of them are becoming known as sort of anti-non-compete, and some of that shows in some of these cases that I'll just highlight. The Kodiak case was in the sale of the business context, as I said, typically given more deference. It's in the construction industry. It was a very broad agreement restriction that was aimed at, in the court's view, not aimed at protecting legitimate business interest and the purchased assets. There's a very close look at what the assets were, and the court determined that the definition of goodwill and geographic scope was far too broad. It involved 2 states and within a 100-mile radius of any location served by the purchased business. And the court said that was just too broad, and it went one step further and said, we're not going to reform this or blue pencil this. Those are 2 different concepts, essentially, but the court refused to modify the agreement to make it more reasonable, which the court has in the past, and the Delaware Chancery Court has done in the past, but this court chose not to do that. In the next case, Ainsley versus Cantor Fitzgerald, interesting, just for prepping for this today, came across the transom that this case was a Delaware Chancery Court, so went up to the Delaware Supreme Court and was reversed and remanded by the Delaware Supreme Court yesterday and sent back to the Chancery Court. And just briefly, this involved a limited partnership agreement in Delaware choice of law. It had a restrictive covenant for a year in it, and also had forfeiture for competition provisions, where if the individual went out and competed, any type of payout that they had gotten under their departure agreement, sort of a payback of capital, if you will, for 4 years, would be forfeited and clawed back, essentially. The court, this was Vice Chancellor Morgan Zern. The court went through a very lengthy analysis, but in some said the forfeiture for competition provision was based upon a worldwide scope and overbroad scope of prohibited conduct, far too broad in the chancellor's view. The chancellor chose not to reform it and cited to the state's policy in favor of robust competition, and said that outweighed its very strong interest in enforcing voluntary contracts like forfeiture agreements, which again, that latter principle has been a bedrock really of Delaware Chancery Court decisions for many years. On appeal to the Supreme Court, the Delaware court disagreed with tipping the scales towards the favoring competition principle versus protecting freedom of contract, and said not so fast, and sent it back to overturned it, reversed it, and sent it back to Vice Chancellor Zern to get to the underlying issue of whether they had in fact non-competed, and whether then the forfeiture provision would come into play. So we'll see. We'll keep you posted on that particular decision, but very interesting. Next slide, please. So the next one, Intertech Testing Systems versus Eastman, different vice chancellor. In this instance, Vice Chancellor Will. This decision came out in March of 23. Again, it was this in the context of a sale of business, which was a workforce training business, which was managed through a proprietary learning system. It was in the food and cannabis industry primarily. It was a $10 million purchase in exchange for a non-compete and other restrictive covenants. New business was set up by this Eastman individual, which was focused on the cannabis industry. And the court said, I'm not even going to get to the question of whether there's competition here in this cannabis industry. There was some testimony, I think, that the acquired entity was not actually doing business in that area at the time of the closing of the sale. But the court didn't get there. The court said on its face it was unenforceable because it was too broad. It was a worldwide no competition clause, and it would impact markets that had not even been touched by the acquired business. Again, one step further, the court went and declined to pencil those covenants and just rendered them unenforceable. So again, another sort of indication that the vice chancellors are taking a very close look at these agreements and are not inclined to blue pencil overbroad provisions. The next one was from Vice Chancellor Zern. It was issued in August of 23, and she granted a motion to dismiss. She went through a very long analysis of whether she was going to apply to Delaware choice of law and compared it to Illinois law and determine whether there was any public policy of Illinois that would be contravened by the application of Delaware law. And she decided that there wouldn't be, so she ended up applying Delaware law. But as I said, it was a very lengthy analysis and not just an automatic acceptance of the Delaware choice of law. She went on to find that the non-compete was not enforceable. It was overbroad from a geographic perspective as well as temporal scope. It was a 2-year provision and U.S. restriction, all of U.S. And she said, taken together, this cast a limitless net over the defendant in both scope of geography and scope of conduct. She took exception with the language of any field that the company planned to enter. And again, failed to or decided not to blue pencil that provision. And then in the next case, this Hightower Holding versus Gibson, a Delaware choice of law was invalidated in favor of Alabama law. The court found this was in the investment advisory business, and the defendant Gibson was a partner in that investment advisory business that had been acquired. He left and started his own hedge fund. As I said, the court wouldn't apply Delaware law because Alabama has an express legislative policy against broad non-competes, particularly concerning professionals. There's a whole definition of professionals, or sort of the cases that evolved on that, and the statute provides some examples. This particular individual's job was not listed, but the court decided that it was close enough and that it would impair citizens' right to receive professional services of their choice. So, and I went on to say, even if it wasn't a defined professional type position, it was still far too broad, and the court refused to blue pencil it. So you can hear the beginning of a theme here in these cases. So we'll see, what continues to happen in Delaware. We've all, I think, on this call or webinar, have had success in Delaware in enforcing non-competes, but there's a little bit more pause now, I think, in this regard because of these decisions. And we'll see what comes out of this Delaware Supreme Court decision to see if there's some, check on what's going on in the Chancery Court. Meanwhile, in Massachusetts, a couple of interesting cases, the Cynosure LLC versus Reveal Lasers case, which involved the manufacture of companies that manufactured medical aesthetic treatment devices like laser hair removal devices. 22 employees left Cynosure and joined Reveal. It was a rating type case. The relevant agreements had Delaware choice of law provisions. 2 of the individuals, however, were resident in Massachusetts, and the court went on to apply some of the requirements of the Massachusetts Non-Competition Agreement Act, which has a number of, I think, about 8 prerequisites that have to be met for an agreement to be enforced. In this instance, a couple of them, particularly the no right to counsel requirement under the statute, was not provided to one of the individuals in the agreement, and therefore the court went on to find that it was not enforceable. Also had some interesting language on other requirements under the statute, which have not been particularly fleshed out in the statutory language. And stock options constitute, they found that stock options constitute mutually agreed consideration, which is a phrase in the statute that's not defined. And then also, this is a principle that's existed prior to that statute, but the start of employment is sufficient consideration for a non-compete. And then finally, the last decision here to talk about in this region is this last decision, which I encourage you all to read if you want to get a sense of what's going on in Delaware. It's the Sunder Energy LLC versus Jackson case, which again declined to blue pencil a overbroad covenant and found overbreadth on a number of the covenants, mostly because of the indefinite nature of them. But for many, many pages in this decision, the court discusses the problem of the Delaware Chancery Court in hearing non-compete disputes, and really expresses a distaste for having to deal with them, given all the other business of the court and the number of cases that come before that court. So I would encourage you to take a look at that as you consider forum and consider the agreements at issue in a particular case and how they will be viewed by Delaware courts. You can go to the next slide, which I think we turn to, is it Michael? Or Robert, sorry. I'll leave it to you two to decide.
A little of both there. That's okay. So Georgia, we'll take a quick look at and Georgia's pretty stable non-compete law. Is a long time ago you had to have hand someone the playbook, and then your agreement could be voided if you didn't, and all that. But Georgia non-compete law has progressed very quickly into more typical state. And so, for example, in a recent 2023 case, Georgia Court of Appeals held that a geographic limitation is required for an employee non-solicit to be enforceable, which is a little different, using a geography, but not unheard of, with the general covenant requirement that there be reasonable time, reasonable geography with regard to covenants. So this is not unheard of or anything that unusual, but further refinement within Georgia. Also, you'll see that the Supreme Court of Georgia has determined that a Georgia court must chime in or make a preliminary decision, as it were, if a restrictive covenant is enforceable indeed under Georgia law before they start going into whether to enforce a choice. I believe choice of law provision. I think we're missing something there, and so that's kind of too significant, or maybe even not so significant, depending how you look at it. Changes in Georgia. We look at Arkansas. There was an attempt to enact a total ban, and there's quite a few attempts to enact total bans in different states around the country. Arkansas, there was one, and that didn't get on committee. Oklahoma generally, Oklahoma generally doesn't enforce non-competes. They have some pretty stringent statutes. There are some exceptions, but they do have a bill pending that would enact a more uniform way to address these things. It's called the Uniform Restrictive Employment Agreement Act, because right now, if you look at Oklahoma statutes and then Oklahoma case law, you see that there's some, I won't say inconsistency, but one goes a little further than the other. So there's been an attempt this year to try to put those all together. Texas, there was an attempt to put in a low-wage worker provision into Texas, but that didn't get past a floor vote. Like I said earlier, there's about 23 states or so that they have these laws now. So the attempt in Texas to do that, that's not too unusual. If you go to the next slide, in the Midwest, go to the next slide. Minnesota, as I'm sure many of you may be aware, Minnesota banned non-competes. They didn't ban non-solicits, but non-compete ban did go into effect this summer. They do have exceptions, such as sale of a business. As I mentioned, non-solicits and non-disclosures are not covered by the ban. And they also have a similar provision to California law that you can't have a choice of law or venue provision outside of Minnesota to try to circumvent Minnesota's ban on non-competes. We've had a lot of clients asking about how do we comply with this? What do we do? What falls within the exceptions? Given the best advice possible, but frankly, there hasn't been case law really, as in most situations, there hasn't been case law on a new enactment of a law that gives us a lot of information. So it's just something that we've developed over time. Missouri, they've come up with new presumptions on enforceability restrictive covenants with regard to businesses and owners of businesses that went into effect in August. The Minnesota ban that went into effect, I believe, is retroactive. And with regard to the Missouri statute, they do have some presumptions, similar to Arizona or Florida, where they have some presumptions on timing. So if you have an employee non-solicit, they're presumed enforceable if it's 2 years or less. Customer non-solicits are presumed enforceable if 5 years or less. And courts are authorized to reform or blue pencil restraints. South Dakota has now banned healthcare practitioners from having non-competes on them. North Dakota, they banned non-competes altogether. South Dakota is starting to move a little bit towards its brother state, although I suppose if you live in one of the Dakotas, you may not consider the other brother state, but that's what's going on there. We'll turn to, I think, Illinois is our next slide. Sorry, Michigan, Wisconsin, close. Illinois will be after this. In Michigan, there is a bill pending to enact a low-wage worker statute in which, as we mentioned earlier, there's a cutoff as to who non-competes apply to. The proposed legislation would have notice requirements and a penalty for each violation, but that hasn't gone very far since it's been around in April of 22. Wisconsin has a bill also that was introduced, and it would prohibit post-employment non-compete agreements. Nothing's really gone on with that yet, and its application to non-solicit covenants is open-ended, similar to California in many respects, where they always talk about non-competes, but non-solicits, you have to dive deeper, look at the case law and figure out the application there. And in Wisconsin, based upon what we've seen, there's probably a sale of a business exception, as in most states. Next slide. Illinois, as some of you may know, Illinois has a low-wage worker statute. Illinois also has generally a two-year requirement that any statute put into effect, any covenant put into effect must be for 2 years as far as a non-compete or non-solicit. A recent case, Midwest versus Horton, the appellate court confirmed a trial court's dismissal of a complaint where a employer was seeking to enforce post-employment covenants. The defendant there was only employed 7 months, so you have a 2-year problem. And so in that situation, that the 2-year rule was upheld, and there was apparently no other consideration. There was a claim by the plaintiff that there was a $25,000 signing bonus, but the agreement didn't explicitly indicate that payment, at least according to what we read, didn't explicitly indicate that the $25,000 was for the covenant, and thus there's a question about adequate consideration since it was only 7 months of employment, which lesson learned there in Illinois, if you're going to use some other form of consideration, because other forms are acceptable and you're not going to rely on the 2 years, if you do give some kind of signing bonus or something else of value that would be considered adequate, you need to document it and make it expressly clear. At least that's what this case helps us to better define. Our next slide. I think finally we're going to get to Robert here. You've been sitting there so quietly and patiently. We're going to get to the Western region, California, our California fellow there, Robert.
Great, thanks, Michael. I appreciate it. There were some significant developments in the West this year. A big development in California. 2 new statutes were signed by the governor. And the first statute makes it clear that non-compete provisions with employees are unlawful. And the second statute requires employers to notify current and former employees dating back to January 1st, 2022, that if they have any non-compete provisions, that those non-compete provisions are void. We'll get into some of the nuts and bolts of the statute momentarily, but I do want to cover some of the other highlights in the West. Montana passed a law banning non-competes for certain medical professions, psychologists and counselors. And then, one thing to be aware of in Oregon and Washington, there's a continual effort and need to look at your non-competes in Oregon and Washington because they have salary thresholds for the use of non-competes in those jurisdictions. And so the threshold for Washington for employees and independent contractors went up for 2024, as well as in Oregon, the salary threshold for using non-competes with Oregon employees also went up. This is a continual exercise, and it's also in other jurisdictions. Our trade secret blog tracks those particular jurisdictions, so I'll encourage you, if you need to get current for 2024, to check out our blog with those salary thresholds. Next slide, please. In 2023, there was also efforts to narrow the use of non-competes in several Western states. And then one thing I did want to highlight for you, because I know a lot of you probably joined this webinar to see what's going on in California. Apart from the two new laws that were actually put into law effective January 1st, 2024, there's another new law, and we'll be blogging another new proposed legislation, AB 747, and we'll be blogging on that shortly. Some highlights on that new proposed legislation is that it'll put a limitation on the sale of a business exception. It'll put a threshold on the use of that exception, and then it'll specify a monetary fine for violating the non-compete statute. And then it'll also put limitations on attorneys using non-competes with possible penalties such as suspension and disbarment. And so that's a significant new piece of legislation. We'll have to see if it actually gets any traction. Next slide, please. And then finally, from a judicial decision perspective, in 2023, as Kate noted, in Delaware, there was some case law about, narrowly construing non-competes and not rewriting the agreement for an employer who may have overreached with their particular language. And we saw that in a Nevada Supreme Court case. In Nevada, they actually have a statute that encourages the courts to reform overly broad non-competes. And so that is very helpful for employers if they got it wrong and perhaps the geographic scope or the duration is too long. But in this tough turtle case, the court made it clear that the trial court is not required to modify an overly broad non-compete, because I think the upshot of the statute was that it was a strong encouragement for the trial courts to reform overly broad non-competes. But the Nevada Supreme Court made it clear that they're not required to do that. Next slide, please. And then before we get into some of the specifics about California, just kind of in a nutshell, and I'll throw it open to Kate and Mike also, but from a national perspective, as far as your trade secret protection agreements, your non-compete agreements, non-solicitation agreements, there's strong encouragement to make sure that you're narrow and that you're focused on legitimate business interests and that you tailor your restrictive covenants. And so you don't have a one-size-fit-all approach for all employees, that you customize the use of restrictive covenants. Perhaps non-compete clauses where they're allowed for C-suite and important executives, perhaps non-solicitation clauses for sales representatives, and then non-disclosure agreements for lower level folks. It really depends upon the jurisdiction, but across the board, you're seeing a really tightening at the judicial level and also at the legislative level. The other thing to keep in mind as far as non-disclosure covenants is that you'll see from lots of agencies a crackdown to make sure that you have whistleblower protections and protected activity protections within your NDA agreements. And so it's a good time for employers across the board to take a look at their non-disclosure agreements, restrictive covenant agreements to make sure that they're current with the current state of the law. As Michael noted with Minnesota, that's now a jurisdiction where you cannot specify an out-of-state forum and choice of law provision, joining other states, such as Illinois and California and Washington State. And so that's those are things that you need to keep in mind if you're a national employer and have multi-state type of agreements. Kate, Mike, anything that you wanted to add in that?
Yeah, in the interest of time, I don't have much else to add. I think you've summed it up nicely. It's on the slide, but it's just a very much of a switch from yesteryear when some employers would go very broad with hopes that the court would reform, and that's just not the situation anymore. So it really is advisable not to overreach and be strategic.
Yeah, and I agree with all that. And let me make one correction. I just double checked. Minnesota non-compete law, it's not retroactive. It's for all agreements entered into after July 1st, 2023. Someone asked in the Q&A that question. I double checked and it's not retroactive. So I misspoke earlier.
Great. Let's jump into California's new non-compete laws. There were two new laws that were signed. The first law came, it was SB 699. And, this particular law, it's very important to understand because I think that a lot of folks, they don't understand the strong public policy in California against non-competes. And so what the legislature decided to do is actually, codify it. And so this is not the legislative history. This is actually part of the law of California. And when clients ask, well, what exactly is going on in California and why would they do something like that? Well, I think if you dive into the finding and purpose of the law, you'll see exactly what they're trying to do. First off, the legislature found and declared that non-compete clauses are extremely common in the United States and that they are chilling employee mobility. Now, this language that you see in the findings and purposes of the law, this echoes some of the same language that you saw from the FTC's proposed rule. So there's a lot of symmetry there as far as what they're trying to accomplish. But what's also worth noting in this particular findings and declarations is that in Section E, they want to make it clear that California's public policy trumps other states' laws. And so why is that important? Because they've codified now that if you have a situation where you have an employee who has a non-compete that's governed by another state's law, perhaps they worked there, perhaps they were an executive in another state, that particular executive, if they were to move to California, they can now attempt to challenge the non-compete provision that would have been valid in their state. And why can they do that? Because that's one of California's public policies to protect not only that employee, but also to protect the California-based employers that may want to employ that particular employee. And that's found in subdivision F of this finding and declaration of the law. And it concludes this freedom of employment is paramount to competitive business interests. And so it's not surprising that some have coined this new law as California's tortious interference with contracts law, because they're not being subtle, they're being direct, that yes, if you come to California, they're not going to enforce or allow non-compete provisions with employees, subject to limited, exceptions. Next slide, please. And so, as part of 699, which was the first law that was passed this year in California on the non-compete, what they want to make clear is that under 16600 indicates that provisions that interfere with an employee's ability to pursue their profession are void. And this particular section, which is codified as 16600.5, takes that concept of void and makes sure that it's clear that such provisions are unlawful, because there was some dispute in the law as far as, well, a particular provision can be void, but it may not be unlawful. And so this particular section wants to make it abundantly clear that such provisions are void and are unlawful, regardless of where the contract was signed and whether the employment was maintained outside of California. Now, this may shock the sensibilities and the notions of fair play of many out-of-state employers and out-of-state attorneys, but this is the law in California, and it provides remedies. Now, a lot of people have said, well, this is not a big change in California law. Well, that may be true to a certain extent. That may have been the practice as far as the case law, and you've probably heard of situations where they have race to judgments, and there may have been support for that under the case law in California. But what this new statute does is makes it entirely clear about what are the remedies available. The remedies available would be attorney's fees, actual damages, injunctive relief. So attempts to enter into contracts that are void, attempts to enforce contracts that are void, are all actionable under this new statute. Next slide, please. A little bit on the legislative history. Shockingly, a California employer actually supported this bill, and not surprisingly, one of the largest plaintiffs' bar associations, employment bar associations in California supported the bill, as well as several law professors, and also, surprisingly, the California Hispanic Chamber of Commerce. So as shocking as it can be to some businesses and employers, there was some support from the business community for this new law. And you'll see there's a lot of symmetry with what you saw at the FTC level about why they want a ban on non-competes. At the FTC level, many of sort of took it at these were statements of a problem in search of a solution. But this is now the part of the legislative history of California now. They say that non-competes are associated with the suppression of wages, and that non-competes are part of the exacerbation of the racial and gender pay gap, and that the bill is there to promote economic equity. So this is now the law in California. Next slide, please. A little bit more on the legislative history. In the interest of time, you'll obviously get these slides and you can go over that, but it's really important to to study that because it'll help you understand why this law came about and what they're trying to accomplish. Next slide, please. So as far as the companion law that was signed about a month later, that was AB 1076. And that's where we get this notification requirement that employers are trying to grapple with. Before February 14th of this year, employers are required to notify their employees that if they have a non-compete, that such non-compete is void. As part of that notification requirement, AB 1076 added the slide that you're seeing in front of you now, which is 16600, contracts that restrain someone from engaging in the profession, trade, or business, they're void. And the new law is amended to indicate that should be construed broadly in accordance with a seminal California Supreme Court case, Edwards versus Arthur Anderson. And then it goes on to say that this is not a change in the law, but a declaration of existing law. So a lot of people may disagree with that, but clearly they are trying to say that there's nothing new here, that this has always been the law in California. And I'm sure we'll see a lot of challenges to that particular statement of the law, but that's what they're saying. And then an important call out is that this law is intended to not just protect employees as far as what employers ask them to sign in their contracts, but also contracts that may impact them. So even if they're not a party to the contract, such as contracts between businesses that may interfere with employees' relations, this is supposed to be this prohibition against non-competes and interference with their profession. it impacts those contracts as well, as indicated in the new statute. Now let's get into that notification requirement. So as part of AB 1076, there's a requirement that if you have a non-compete with your current employee, that you notify them by Valentine's Day that that non-compete clause or non-compete agreement is void. And it also applies to employees that were on your payroll who were California employees that may have left you after January 1st of 2022. Now, the legislature did not tell us what a non-compete agreement is. And so now employers are struggling to understand, their restrictive covenants, their non-disclosure agreement. Do they have non-compete agreements for which they need to provide notice? If they do have non-compete agreements for which they provide notice, what do they have to do? They have to send an email to that employee, and they also need to send a communication to their last known address. So two methods of communication, email and their last known address. And what are the consequences if you do not provide the notice? The consequences is that it's an act of unfair competition. Now, Section 17200 has a provision as part of its companion statute that indicates that a violation could be a penalty of $2,500. And so that's obviously what some of the consequences will be if you do not comply with this particular provision. It obviously would have been very helpful if the legislator would have told employers what a non-compete provision is under this act. And so that's sort of what the type of the counseling and the work that we're being asked at this point, to help employers with. A little bit about the legislative history about AB 1076. It was supported by the California Attorney General. That's significant because the enforcement arm of California Attorney General will likely go after employers that do not provide the notice. As part of the legislative history, there was an indication that there would need to be an increase in budget of the AG's office so that they could get enforcement and compliance with this new notification requirement. There was also support for the new law by the plaintiffs' bar, the Teamsters, and it tells you also the Nurses United, a union for the nurses. They were also in support of the legislation. Next slide, please. And then I think this is going to be very important, as this law develops, is that there's some statements in the legislative history by California's current Attorney General, Rob Bonta, about why this new law is necessary. And he explained in the legislative history is that the Edwards decision confirmed that non-compete clauses are unenforceable, and he indicates that putting an unenforceable term in a contract is not necessarily unlawful. And so I think we'll see a lot of litigation in the future about what this all means and what kind of liability that there can be for past use of alleged non-compete. And then this also tracks that as far as that they're going to have an increase in budget for the Department of Justice of California for enforcement. And so that's obviously why employers are very concerned about making sure that they provide the necessary notice under the law. So in sum, our slide 41 sort of sums up what the upshot of SB 699 and AB 1076 are. And let me throw it over to Mike and Kate, because I know that as well as myself, we've been counseling a lot of clients about how to deal with this new law, and want to sort of bubble up to the surface some of the issues that you guys are seeing with clients about this new law.
Go ahead, Mike.
Sure. So, we're seeing clients that have questions about the status of an employee, meaning the statute says that the notice is required for anyone that was an employee or is an employee after July 1st, 2022. And, the question comes up, what happens if someone had a 1-year non-compete and they left already and their 1 year's expired? Why am I sending a notice? Because they're no longer with me and their covenant expired. We're seeing questions with regard to how notice is sent. It has to be email and a letter to the last known address. People are asking, well, what about an agreement that has language that appears to comply with California law with regard to a non-compete, but then also has in there a non-solicit of employee? And what do you do about that? Because the statute only mentions non-competes. It doesn't mention non-solicits whatsoever with regard to a notice. So, folks are asking that question. Folks are also asking, well, can I change my agreements now so that I don't need to do anything? Should I amend them now so that I don't have to do anything? And how does that fit in with the current regulatory scheme? Folks are asking, what do I say in the notice? Do I say something that later, as Robert mentioned a moment ago, that later some class action attorney is going to say it's some kind of admission? So what is the language I need to do with the notice? So in addition to deciding who to send it to, what do I say? Folks are asking questions about what happens if I'm a California business. I have employees across the entire country. Do I need to send notice to anyone in those different states because they're not residents of California? And the converse. What do I do for someone who let's just pick a Massachusetts-based business and they have someone that moved to California? What do I do with that person? Do they get a notice because they're now a California resident, but they signed their agreement before July 2022 or after July 2022? So we're getting all kinds of questions in that area with regard to that. And so, yeah, that's what's going on.
I think in the interest of time,
yes,
we're going to go ahead and give you guys the CLE code, and we'll welcome you to continue to discuss this with us. I think we'll stay on for another 10 minutes or so, but the code for today's CLE credit is SS 3687. Those that can continue to stay on the call, please do so. If you have to go, thanks for participating, and you'll get a copy of the deck. So I think the other thing to point out about the new law, next slide, please, is how is this going to interact with California Labor Code Section 925, and why is that significant? Well, Labor Code 925 prohibits California employers from using out-of-state choice of law and forum provisions with California employees. But there is an exception if that employee is in fact represented by legal counsel. And so the question is, can you contractually agree to another choice of law outside of California if you're in fact represented by legal counsel? And I think that's going to be one of the litigated issues. And one thing to note is that the new proposed law, AB 747, seemingly indicates that does continue to be a viable exception because it tries to modify some of the obligations under 925. And with respect to this new law, you can imagine that out-of-state employers are somewhat irate that what they think to be a binding non-compete with, high-level folks or employees generally can basically be written away by that employee, moving to California. There's going to be challenges of this new law in those states. There's going to be interesting issues that come up with respect to full faith and credit. We expect that there may be some constitutional challenges of that law. That's little respite, little peace of mind for employers that are having to deal with the new law, though, and the compliance obligations coming out of it. Next slide, please. You'll see on slide 43, this is sort of a checklist that you can use how to come to terms with the California new law, how to come to terms with the notice obligations. It's applying to California employees. We see a question in the chat. What about these former employees? Is it just people that were hired during that period of time of January 1st through 2022? No. It's talking about anybody that was a California employee as of January 1st, 2022. If you had a non-compete with that employee, you need to provide notification that non-compete is void. And then, so going through the process of analyzing the restrictive covenants, determining whether it's a non-compete, providing the notification, updating your existing agreements, considering whether you want to do amendments to those existing agreements, how to deal with the situation of, and this is coming up, quite commonly, is say you have somebody that was in Massachusetts, rather high up in the company, that has moved to California and is working for you in California, and they signed a non-compete with you in Massachusetts. But they now are working in California. You're treating them as a California employee for payroll purposes. Do they have the protection of the new statute? And most likely, yes, and that you would have to provide them notification about the non-compete. And then I think Mike hit it on, we expect, since the plaintiffs bar, so, plaintiffs association was, highly involved in this new law, that we expect to see class action lawsuits, PAGA claims coming out of the new law. And we've highlighted some of the, the frequently asked questions that we're getting from clients. The next slide, please. Whether it's irony or intentional, they've set this notification deadline for Valentine's Day, February 14th, 2024. So be sure to reach out to your SIFART attorney if your company's struggling with complying with the new law. We expect to see a lot of flurry of activity in the coming weeks as companies get ready, to comply with the law. As you'll see on slide 45, part of the assessment is looking at your restrictive covenants, and it's also a good opportunity as you try to comply with this new law to take a look at your NDA, your non-disclosure agreement. Make sure you have all the other bells and whistles. We talked about the SEC wanting to have magic language, whistleblower language, some of the other entities. California has, unique requirements under the Speak Out laws, as well as their pay equity laws. So it's a good opportunity to make sure that your form non-disclosure agreement with California employees is up to date. With that, I think briefly I'll turn it over to Kate to give us a brief update on the trade secret law.
Yeah, thanks, Robert. I'll go through this pretty quickly because I know we're over time here, but there have been some interesting decisions, court decisions, and expected decisions that we'll see, we think, in 24 on damage issues, as well as the measures that are necessary to protect the secrecy of trade secrets. And the first decision is the Sintel decisions, Sintel Sterling versus Dryzetto. There's a lot on the slide. There's a lot on the case. I encourage you to read it. But really, it's a Second Circuit breaking from other circuits that have addressed the issue of unjust enrichment damages being recoverable without corresponding harm to the trade secret holder's value. So I encourage you to take a look at that. I'm sure there are a number of courts that have reached that decision differently than the Second Circuit. So I'm sure we'll hear more on that, and encourage you to take a look at the reasoning of that case. Next slide. Next slide, please, Sadie. The Seventh Circuit, no, I'm sorry, go back a couple. I got ahead of me. There we go. The Fourth Circuit in Synopsys versus risk-based securities dealt with proving the independent economic value of a trade secret and demonstrating that the value actually emanates from the trade secret being secret. And courts have long acknowledged that to qualify as a trade secret, you have to show that it has independent economic value derived from secrecy. And many commentators and lawyers have said that courts have really sort of relied on inferences to establish that, or assertions of hypothetical value rather than meaningful evidence. In the Sintel case, the court found that the value of an overall database as a whole was not sufficient to prove the value of 75 individual trade secrets. The court said that the plaintiff needed to show the value of the independent trade secrets versus this one sort of wholesale demonstration of value. So please take a look at that case and look at the reasoning on that. And then similarly, in a June decision as well, in this healthcare facilities case, the court granted summary judgment, noting that there were conclusory allegations of competitive value. And in that case, a very, from the court's perspective, conclusory affidavit of the CEO was rejected as not sufficient. It referenced, what has typically been found to be okay in these instances: pro formas, unaudited financial statements, and example of economic terms of certain transactions that had undertaken. But the court looked at that as very subjective testimony and instead needed objective indicia of independent economic value. So very important to focus on, the actual independent value that derives from the secrecy of the particular trade secret. And then next slide. In the Motorola Solutions case, we're expecting that we may have the first appeals court case in 24 on the application of the DTSA to misappropriation that takes place outside of the United States. And you can see from the slide that here the district court disgorged the defendant's full worldwide profits from the sale of an accused products under the DTSA, and found that the reach was not outside the United States. And that case is currently on appeal before the Seventh Circuit, and actually was argued on December 5th. So we expect to see a decision on that very soon in 24. The next slide. I think this is you, Robert.
Yeah, we saw a significant case. Just reminding everyone that the use of a non-disclosure covenant is obviously one of the main things that the courts look to see if there's reasonable secrecy measures in place. And in this particular case, there was no non-disclosure agreement, but the defendant was still sued. And I guess the argument would be that there was some sort of special confidential relationship. The court rejected that and said that if you want to maintain a claim for trade secret misappropriation, you need to have an NDA, and they're not going to impose or imply any sort of special confidential relationship when it's an arm's length business transaction. Next slide, please. We didn't see any astronomical jury verdicts like we did the year before. I think 2 years ago we saw a $2 billion trade secret jury verdict, but we continue to see large jury verdicts in trade secret cases. With the ratcheting down on non-competes, we suspect that we'll see an uptick in trade secret misappropriation litigation. I think some of the legal commentators noted a uptick in trade secret case filings in the fall of 2023. And we're going to continue to see that. Next slide, please. With that, I'll turn it over to Mike to bring us home on a brief update on computer fraud.
And just quickly, on the computer fraud area, the Supreme Court chimed in the Van Buren versus United States case regarding the split in the federal circuits about what exactly unauthorized access is. And the bottom line is that an employer needs to take efforts to limit access to confidential information. And if an employee who has proper access, but uses that access for an improper purpose, that is not unauthorized access. So the key here is for employers to take steps to limit information, even within the company, so that someone who goes in and does something improper, they violate that access, because access is key. So you want to make sure that you may authorize employees to see information at certain levels, depending on the level in the organization, or depending on their password, or maybe it's limited to certain groups of people, and someone outside that group goes and gets access. Unauthorized access is key. A lot of cases, a lot of people think just because someone does something improperly but has authorized access to the information, and they do something improperly with the information, that violates the unauthorized access prong. It doesn't. So that's key. Second, the next thing we can talk a little bit about here is with regard to form nonconvenience. There's a lot of bullets here, but the bottom line is there's been some case law talking about what the proper forum is with regard to and where the harm is with regard to computer fraud and abuse cases. And you need to be cognizant of where where you're bringing a claim, where the harm is, what courts have jurisdiction over a computer fraud and abuse claim, so that you don't get into a situation where you're enforcing something in the wrong form inside the U.S. or potentially outside the U.S. If you take a look at this later, you can see the dichotomy that took place in the Apple case that's described there, and you can see how that applies. Next case. Sorry, next slide. Employees sabotage your computer systems. In short, a bank employee went in and pled guilty for violating the Computer Fraud and Abuse Act because he obtained information from a protected computer, and and there were false statements made to investigators, and so based on in that situation where there was then a second indictment that he used his company computer and he didn't return the computer, that he had access to bank's network and caused a substantial damage. So you need to be aware, obviously, of criminal implications, but also you need to understand that with regard to that case, that the information that was emailed in that case to the person needs to be valued over $5,000, and that remediation counts towards that, towards that number. So you always have to have that $5,000 requirement met in a computer fraud and abuse case. So this fellow got a prison sentence and had restitution of about $500,000. So you need to be aware of what the Computer Fraud and Abuse Act covers. And then the next the next case talks. It's basically it was a class action case talking about information and whether information was improperly obtained, and whether or not these plaintiffs brought a claim against the car manufacturer, saying that the car manufacturer was having improper access with regard to a vehicle through the OTA, which is over the air. A lot of electric vehicles are controlled by over the air transmissions from the manufacturer, both to upgrade, update things, and also to get performance information. And the claim was that somehow battery systems were being devalued because of this. And the court found that there wasn't unauthorized access in that situation because the access was authorized. The car manufacturer always had access under the purchase agreement to provide information and to get information from the vehicles. Again, you need to understand what unauthorized access means and what access is being given to folks so you can properly protect things if you want to use the Computer Fraud and Abuse Act. I think our last slide, data theft and whistleblowers. In short, in that particular case, there was a jury verdict where a jury agreed with a CEO that information was improperly obtained by an employee. At the end of the day, that was reversed, essentially saying that the employee who got the information was more or less a whistleblower. So it's I jokingly say, hey, if you're a whistleblower, you can't steal things. It's all good to go. But that's probably a very glib view of all this. But the critical piece again is understanding authorized access, understanding what information, how to protect information, and understanding what constitutes a computer fraud and abuse act claims. Next slide. Any questions? I suppose if there's questions in the Q&A, you can answer them. We gave you the information with regard to the code, and we'll try and answer some of the questions in the Q&A after the presentation.
Just for those folks that didn't get the code is SS 3687. That's the CLE code. And then please join us for our next webinar. We're going to have another webinar navigating the intersections of non-compete agreements and employee mobility. You can sign up for it on our blog, tradesecretslaw.com. It's on Tuesday, February 20th. Feel free to reach out to us. I think we answered most of the questions that were in the chat function, but feel free to reach out to the panelists or your Cyfarth attorney if you have any questions. Mike, Kate, anything else you wanted to add?
No, just Big thank you to you too, and to everyone attending.
Yeah, thank you, Robert. Thank you, Kate. Glad everyone could attend. Hope you found it helpful. And anytime you want further information or have a topic that might be interesting for a webinar for us, please contact us and let us know. We're always interested in seeing what the public wants to hear about, and we try to respond to that. So feel free to contact us and let us know how we can be of assistance.
Very good.
Yeah.
Goodbye. Have a good
Bye-bye.
afternoon, everyone. Take care.